this is a new, rare question. I think it's very valid for those of you that want to understand due process and the statute of limitations and also prior written notice and sort of how the courts feel and apply this particular aspect in the law. All right, you have some questions in reference to section 1415 that someone may be able to help with. That would be me. Exceptions to the timeline, and this is directly from the IDEA pertaining to statute of limitations and the extension past the statute. There are exceptions to that, and there are certain rare, I'm going to say that again, rare instances to where at time the statute itself can be extended. Those rare circumstances, though, would have to be clarified and laid out explicitly, and because the courts have been rather consistent with regards to providing schools some deference, heavy deference. I mean, why? They're the government, and government gets a lot of deference in every situation, whereas we, as regular citizens, as parent attorneys, we don't get those same kind of, is it fair? No, it's not fair. But life isn't fair when you're dealing with a government body. Okay. I'm an idealist, guys, but I'm also a realist about what we are dealing with as a country, as a people. Okay. So the exceptions to the timeline, it shall not apply to a parent if the parent was prevented from requesting the hearing due to specific misrepresentations by the school that it had resolved the problem forming the basis of the complaint, or the local education agencies, which is the school, withholding of information from the parent that was required under the subchapter to be provided to the parent. Now, that would be broad, and so you would think, okay, well, how is that applied? Well, a specific misrepresentation that a problem was resolved, well, like I said, you would have to sit there and lay that out and explain that. You would need to raise it, number one, in your complaint, meaning that as one of the issues in the complaint, you would need to say that the statute of limitations with regards to corrective action or compensatory needs to be extended, and these are the reasons why. And then you would need to lay out what misrepresentations were made by the school to where you thought that the problem was resolved, and then you would need to have the evidence to show that. Now, would the prior written notice be something to where you could show that? Yeah, you could, but then let's get into that second part of your question. Your question is about the extension or exceptions when filing due process not receiving prior written notice requirement and the denial of FAPE. If a school neglects prevents, see, that's why I wear glasses, to provide the prior written notice, isn't it withholding information and preventing us as parents from meaningful participation in the IEP process? If the school's common practice is to not provide it, wouldn't that be grounds to extend the statute of limitations beyond the 1 year mark? Now, 1 year, I don't know where you are, but the only state that I know of that has a 1 year statute of limitations is North Carolina. The remaining states, even Texas, was 1 year until this last year, and then they extended it to 2 years like everybody else, except for North Carolina, to my knowledge. So if you're in North Carolina, then yes, it's 1 year. If you're in another state, then it's 2 years, unless it's, I mean, if I'm wrong, let me know. But it's my understanding that North Carolina is the only holdout with 1 year. Okay, it's 2 years, and so how could you extend it? And I can tell you that there is a case to where it would be a good one to research, and it's out of the 11th Circuit Court of Appeals, which covers Georgia and Alabama and Florida. But it's a controlling decision that you can cite even where you're located, wherever that is. Okay, and so it's called the Draper versus Atlanta Public Schools. Okay, Draper, D-R-A-P-E-R. And that one, they went past the statute, but there was problem after problem after problem. And if you read the decision, you'll see how they laid out that argument to be able to show that there were a lot of misrepresentations made by the schools and by the school, and a lot of deception, lying, failures to even act and move forward. And so in those situations, the court said, hey, you know, we're going to extend the statute because of educational damage done to the child due to these problems. I can tell you that's a rare circumstance. So you're going to need to sit there and have definitive evidence. Now, your question involved the prior written notice. Now, this is something that when people go PWN, you know, it's prior written notice. Now, the word that is very important to understand in that is prior, okay? Is that prior denotes that there's going to be changes in the IEP itself that the school is about to implement. Now, the IEP team, you're a member of the IEP team should make those decisions, but there are times when, let's say, there's not consensus on the team, there is a disagreement, and the school is proposing to make changes in the area of provision of FAPE, identification, eligibility, and placement. Those are the things that require prior written notice. And so at that point, if there's any proposed change that is going to be made at an IEP, then that is when they're required to provide prior written notice, meaning that you need to be provided notice prior to the implementation of those changes. Now, at the same time, is that required all the time? No, it's not. It is, but what I'm saying in the case of courts and how courts decide this stuff, what schools will defend themselves with is saying that the information contained within the IEP itself was sufficient to provide to meet that standard of prior written notice. And like I said, they will give deference to the schools when they're arguing that point, that there was sufficient information within the body of the IEP, either in the amendment section or somewhere in the IEP, that let the parents know that changes were coming, that changes were being made, that the parent was aware, the parent had a copy of the IEP, the parent had a copy of their procedural safeguards, the parent had a copy. If they have documented proof of this stuff, and guys, and I'm telling you that with 100% certainty, in every case I've had to actually go to hearing on, and I'm talking about actually go to hearing on, in 100% of those cases, guys, we have caught the school either holding back documentation, manufacturing documentation, destroying documentation, or even to the point where one of the schools, and this is one of our cases that went to the Court of Appeals, to where they actually fraudulently assigned names of people that weren't even in the county at the time that a meeting took place, and somebody signed their name as though they were present and there. So we have busted schools in 100% of the cases where I have gone to due process and I have argued these, we have busted them. So to sit there and say, well, they didn't provide me this or this or this, okay, that's your argument, but I can tell you it's just not that difficult to sit there and notate on a piece of paper somewhere that they had mailed it to you, and somehow it's the postal, you know, service's fault, and you know why you didn't get it. And you sit there and you go, well, the only counter is, well, you guys have always either sent it home or you guys have emailed it to me as an attachment, and now this time you mailed it. Those things are compelling, and you can provide them as evidence, as counter, but I'm telling you, sometimes it gets extremely difficult and hairy to try to prove that the school did not provide you X, Y, and Z when they're in control of the education records. And it's just not that difficult to sit there and manufacture this stuff. It's just not, guys. The one thing I will tell you, though, is that because of technology, so much of this stuff is now watermarked as a security feature. And that is one of the things that many parents are not aware of, is that if I end up going to a hearing, the one thing that I will request is I will request a basically a security printout of logins and access to the child's, let's say they use PowerSchool, which most states use PowerSchool now, to safeguard or as part of the special education process and the documentation. Anybody who accesses your child's file, it's going to sit there and give a specific IP address, where it was accessed from, who accessed it, or which computer accessed it. I mean, I guess somebody could get on somebody else's computer and access PowerSchool, but at the same time, you would have a marker as to when that happened, and then on top of it, any documents that would be produced that would be official and officially generated through PowerSchool would be also marked as far as the date and the time that that particular document was produced. In yesteryear, when it used to be called SETS, well, that's a different product than PowerSchool. PowerSchool is fairly new in the grand scheme of things, but used to, SETS would have watermarks at the bottom of the page, and when I'd go to hearing, I would always find it interesting if that bottom portion of the page of when that document was produced was conveniently not there anymore, meaning that they just, cut off the bottom of the page before, sending them to me. Sometimes it didn't matter, sometimes it did matter. And at that point, I would dig a little deeper. But this is the thing, those things are there as a security measure. And, those would be some of those things that you could request in a hearing or prior to. I mean, you would probably have to subpoena that, and you'd have to be specific on what you're looking for. But every school now, because of the technological advances, is going to have somebody that works in their tech department and would be able to produce that documentation, and I'd find out who that is. I would subpoena that person, and they would need to bring those documentations, provide them to you in advance for your review, to sit there and ensure that these documents weren't just manufactured. If anything's handwritten, come on, I can sit there and take a document, backdate it, 5 years if I wanted, 100 years if I wanted to. It's just not that difficult. I'm just telling you, and preparing people for the reality that schools manufacture documents all the time to safeguard and protect themselves, okay? And you sit there and you go, well, that's disgusting. Yes, it's disgusting. Yes, it's wrong. Yes, it's illegal. At the same time, does it raise to the same level of illegal that is applied to us now? I mean, I can't even tell you how many times I've attempted over the years to get district attorneys interested, to get the feds interested in the destruction of documents and misuse of funds and fraudulently created or signed documents. You know how many times any of them have cared? This many, guys. 0. I've got a problem up in North Alabama to where I'm almost going on a few months. It's going to be going on a year trying to get a district attorney and police department to acknowledge abuse of a whole class of students, to where the aide and the teacher is held to account for what they did. And I mean, we're still trying, we're still pressuring and working on that. I'm just telling you, nobody's interested. Yeah, does that mean that, to take the wind out of you? Yes. Does that mean you stop fighting? No, you don't. You just have to be realistic about what you're dealing with, and you're dealing with government. All right. So when it comes to these prior written notices, yes, they can serve to prove these things. At the same time, like I said, you would need to lock up that documentation to sit there and tell a story. You would have to tell your story, and that document would need to coincide and support that, just like what the law says, that they made specific misrepresentations. And, if you get these people on the stand, they're not going to admit that they did that. Some of them may. All this stuff needs to be written down in email, but it would need to be specific misrepresentation, lies. that you relied upon, that things were resolved, and that they went through the extra efforts of deceiving you and thinking that those problems were resolved, and then you find out 3 years later, which is a year after your statute, that they lied to you. At that point, that would be a provable specific misrepresentation, but you would need to absolutely have it nailed down. Like I said, you're dealing with government, and you're dealing with their ability to get heavy deference to the fact that, it was a mistake, it was an oversight, it was an error. And I'm telling you, courts are government, and courts are going to give deference to other governmental agencies. Is it right? No, it's not. Are we as citizens held to a different standard? Yes. Is that get worse in a corrupt world? It's absolutely intolerable in a corrupt world, and we're in a corrupt world right now. The local education agency's withholding of information from the parent that was required under the subchapter. And like I said, withholding that information, it just it's broad enough to where it's arguable, but then you need to sit there, like I said, and be able to package that story and have it provable with documentation, not word of mouth. Why is that? That's called peril evidence, guys. And I mean, unless you can sit there and get these actual people to sit there and admit that they did X, Y, and Z, then, and then hearsay, you'd be surprised in hearings where the school hearsay tends to be permittable, that whereas it's not for a parent. Like I said, deference. These are we can argue these things successfully, and we've been very successful in arguing these cases. But the reason we're successful in arguing these cases is that I am a realist about what I'm up against. And so therefore, if I understand where my obstacles are, I understand how I need to navigate around them. Okay? And that's all I'm recommending.